et al. Versus James H. Griffith Jr. et al.
We'll hear from the appellant when you're ready.
Brad Sproles here from the Sullivan County Bar on behalf of James H. Griffith Jr. I would, just for the record, point out that listed appellee is Lyon Roofing, Lyon. The appellee here today is the city of Mount Carmel, and this matter is results from the denial of a Rule 60.02 motion by the Hawkins County Circuit Court. The appellant had filed that motion asking the court to review the granting of summary judgment on behalf of the city of Mount Carmel. Attached to their summary judgment motion was the opinion of an expert witness whose credentials are unquestioned. That expert opinion based at least partially on the statement that the backfill material for this retaining wall was red clay dirt rather than stone. The construction situation was such that it was unable to be tested, and we assumed that was correct. He was the expert. Once the case was over, the building was demolished, heavy equipment was able to be brought in, and the wall was taken down. We discovered that the backfill material was in fact stone instead of dirt. We then filed the Rule 60.02 motion requesting the court to look at that, essentially because the expert opinion was based on erroneous factual information. Our issue here today is very straightforward, very simple, Your Honor. The court denied the Rule 60.02 motion without allowing us to present evidence to that effect. I think that we're in agreement the standard of review here is an abuse of discretion. And I think that the court's denial is very important to that standard because we quote in our brief that when a party seeks relief from a final judgment pursuant to Rule 60.02, the burden of proof rests with that party. Furthermore, the party seeking relief must offer proof of the basis on which the relief is sought. We were not allowed to present that proof, therefore we could not have carried our burden. And for that reason, Judge, we do believe that it was an abuse of discretion by the trial court because they applied an incorrect legal standard. They denied us the opportunity to carry our burden of proof.
And the expert report said that whether it was clay or rock, it would have failed anyway.
You're correct, Judge, and I have never denied that. I think that the transcript will show that the trial court even asked me about that. And I guess my response, my position on that, Your Honor, is that respectfully, I think that was an improper question for the trial court to ask. I think that substituting my judgment on that for the trial courts, I think the proper procedure would have been for the judge to hear the proof and make that decision.
Well, but I mean, you could have presented proof before the summary judgment was granted that even if you didn't know it was rock or whatever, to the effect that it wouldn't have failed. I mean, you could have hired an expert who could have said, you know, we don't know if it's rock or clay or dirt or sand or whatever, but if it wouldn't have failed if it had been rock.
You're right, Judge, and
okay.
I concede that fact. I think just in retrospect, looking at the case, I don't think I saw that as an issue at the time until we realized that it was something different than what the expert had relied on. The entirety of the case, as far as my client goes, was based on the building itself, not the wall. The problem with the building is there was engineered roof trusses that were wood, were built and delivered and left in the weather for an extended period of time. When they were installed on the building, it created an unsafe building. It failed. It eventually had to be torn down. So that was our focus. So I'm not offering that as an excuse, just it wasn't something that we considered at the time until we realized there was a difference in what the backfill material was. And Judge, I don't feel a need to reserve any time. So.
Okay, thank you. Hear from the appellee.
May it please the court, Your Honor. Chris Rhodes from the Sullivan County Bar, and I represent the town of Mount Carmel in this case, Your Honor. Counsel is correct that we are here on abuse of discretion standard based on the trial court's ruling. And there is a little bit more information for purposes of the oral argument that I would like to share with the court. At one point during the Rule 60 motion, again, because we have a final judgment that had been down for approximately almost a year when the Rule 60 judgment was filed. That was an issue I brought up at the trial court. The trial court concluded that he found that the motion was timely because it was within that 1 year time period, so that is not before the court. The issue here, I guess, is ultimately the finding as to what the court concluded with the wall. And at one point, as far as the hearing goes, the judge actually asked counsel if pictures, photographs that they intended to introduce showed that the wall was backfilled with rock. Counsel essentially said, that is correct, that's what the proof. I take that as absolute truth. I take that as absolute truth. Have no reason to deny that proof. Ultimately, though, the problem is the expert that the town of Mount Carmel retained performed a site evaluation, concluded in his report, and we attached the entire report with our motion for summary judgment, that yes, in the report he stated that the backfill was clay. However, I think it's conclusion 3, he noted that even if the wall was backfilled with rock, crushed stone, and maintained adequate drainage, the wall would still be in a state of failure due to lateral earth pressures. Now, a Rule 60 motion, as this court is aware, essentially there's 5 various avenues to exercise a Rule 60 motion. One is mistake, inadvertent, surprise, or excusable neglect. And the 5th one is kind of the catch-all provision or any reason justifying relief. A Rule 60 motion is an exceptional remedy. Policy in Tennessee favors finality of judgments. And so as a result, the courts have kind of described Rule 60 as an escape valve. And that escape valve is not to be easily opened. In other words, there needs to be some proof. In our expert report that was attached to our motion, there are calculations detailing why he felt that the wall was in a state of failure due to lateral earth pressures. As we sit here today, even with that heavy burden for mistake, inadvertence, or excusable neglect, those calculations have never been debated. There is nothing in front of this court that really focuses on the lateral earth pressure. The only testimony before this court, or the only evidence that was considered or attempted to be introduced by counsel, was the backfill material. And the report clearly establishes that. As a result, we would argue under Rule 60.02 that their burden is not satisfied, given, under Rule 60.02(1), that the escape valve is not easily opened. It's a very high burden. Also, under Rule 60.025, Your Honor, it's actually considered an even more demanding than the other four provisions. And we'll go back to language in Byrd versus Traufer. Rule 60.02 gives the courts very broad power, but the power is not to be used to relieve parties from free, deliberate, and calculated choices in litigation. And we're here at this point after the judgment's been filed, Your Honor. We were granted summary judgment by Judge Wright in Hawkins County Circuit Court. There was a time to attempt to obtain relief from that judgment. That was not pursued. There was the ability to appeal that judgment based on the ruling from the trial court on the motion for summary judgment. That was not done. Now they're here on Rule 60.02 motion, which is an exceptional remedy under Tennessee law, asking the court to lift the final judgment due to backfill material. And as our expert concluded, the backfill, the wall fails whether it was red clay or whether it was rock. And as a result, Your Honor, we submit they have not met their burden, and we respectfully ask that the court's ruling denying the Rule 60 motion be upheld.
Court's thanks to both counsel. Have safe drives back to Upper East Tennessee. Would recess court till this afternoon, please?
All rise. This court is at recess until 1:30 p.m.